Welcome to this Washington Legal Foundation webinar. I'm Glenn Lammi, Executive Director and Vice President of Legal Studies with the Washington Legal Foundation. For those of you not familiar with the foundation, we are in our 47th year of public interest law, advocacy, and education on a pretty wide range of issues that affect the free enterprise system. Our mission is to try to create a legal and regulatory system that is favorable to free enterprise. If you have any questions about the foundation or interested in finding out more about us, spend some time on our website today. We're pleased to have assembled this panel of experts to preview the December 10th oral arguments for 7-County Infrastructure Coalition versus Eagle County, Colorado, and discuss the case's significance in a broader context. The law at issue in this case is the National Environmental Policy Act, a statute that the Supreme Court has said, quote, does not mandate particular results, but simply prescribes the necessary process for federal agencies, unquote. This process prescribing law has taken on a role in the approval of permits for major infrastructure, energy, and other projects that arguably goes well beyond what Congress intended. As a brief authored by one of our panelists today so artfully relates, quote, when the law becomes so indeterminate that compliance is almost impossible, there is a problem. The problem was not created by NEPA, a simple and modest good government statute, but by the fearsome procedural nettle that activist courts have turned it into over the years. That was a brief done by as I said, by one of our panelists today. So I'll start introducing them first. That was Mario Loyola, whose brief in support of petitioners for a group of law professors included that excellent statement. Mario is a research assistant professor at Florida International University and director of its environmental finance and risk management program in the Institute of Environment. He teaches administrative and environmental law at the College of Law as well. He's also a senior research fellow at the Heritage Foundation. He's a former associate director for regulatory reform at the White House Council on Environmental Quality. He's authored, as I said, the brief in support of the petitioners in this case. Joining us also is Christopher Thomas, who's a partner in the Phoenix, Arizona office of Perkins Coie. He focuses on complex infrastructure, permitting, natural resource and hazardous substance litigation, enforcement defense, and site remediation. Chris is an elected fellow of the American College of Environmental Lawyers and a frequent writer and speaker on environmental and natural resource topics. He and 3 Perkins Coie colleagues represent a coalition of mining and exploration organizations on an amicus brief supporting the petitioner in the 7 counties infrastructure case. Finally, Chad Whiteman is Vice President, Environment and Regulatory Affairs with the U.S. Chamber of Commerce's Global Energy Institute. Before joining the Chamber, Chris was Deputy Chief of the Natural Resources and Environment Branch in the White House Office of Information and Regulatory Affairs within the Office of Management and Budget. He also previously served at the U.S. Environmental Protection Agency, developing and implementing Clean Air Act policies. The Chamber Litigation Center filed a brief in the case as well in support of the petitioner. I'm going to let our viewers know that this program is being recorded. If you have any questions for our audience, please put them in the Q&A function in the Zoom webinar toolbar, and we will get to them towards the end of the program. Chad, if you could start us off, give us a quick overview of NEPA, how it applies in the context of awarding permits for major projects.
Happy to do that. And Glenn, thank you for the invitation and great to join everyone today. Just going back to NEPA as a statute, of course, it was signed into law in 1970. And it had these big, broad goals, right? Goals of encouraging productive and enjoyable harmony between man and the environment. It directed the federal government to identify and develop methodologies and procedures in consultation with CEQ to assess, to quantify environmental amenities, values, and give them appropriate consideration in decision making. So a lot of broad goals on things that agencies are supposed to consider on something that is in their purview, a federal action that they're required to approve, or either a private party or federal government wants to take. So anything from major projects like land management projects, whether it be mining on federal lands or forestry projects, anything that require federal funding. So a lot of our roads and bridges, so many of them, of course, major projects, And typically what would happen for these major projects is they would be required to go and develop an environmental impact statement and to consider and assess the environmental effects of an agency's action to approve that project or that action or give that authorization. A lesser level of NEPA review, they can go through an environmental assessment. And after going out for it with public comment, if the agency determines and comes up with a finding of no significant impact or FONSI, then they can proceed without doing the full-blown environmental impact assessment. And finally, most major projects wouldn't really fit in this category, but categorical exclusions where there's no significant impact on the human environment, and that for a particular category of actions, they don't have to go through the NEPA analysis. But what is interesting is, again, the statute was passed in the 1970s. There's been a lot of litigation on NEPA. It's the most litigated environmental statute out there. And what that has led to is the development of all these environmental impact statements and the litigation that's followed. Getting a permit now takes about 4.5 years on average. Uh, Roads and bridges on average, like over 7 years. Mining, these are decades-long projects, and transmission lines are taking just as long as well. The average EIS now is 1,700 pages long, including the appendices. If you go back to one of the original 1984 guidance documents issued, their goal was to have EISs be like 150 pages, right? To be really short, concise, consideration of the environmental impacts. So there's been a lot that shifted. You'll have multiple agencies now that can and often do their own independent environmental analyses. So things get really complicated. And that's not even talking about the litigation that follows afterwards. So you get 4.5 years just to get your permit. Once you get your permit, then you have litigation that can follow for these major projects. Often there is something. The Breakthrough Institute put out a report early this year saying it takes about a little over 4 years, 4.2 years, just on average to get through the litigation process. So when you add all these things up and you look across the economy, and we can talk about this more later, but there's a lot of stuff we want to build. There's been a lot of funding that Congress has put out there, and NEPA has really evolved into something that's really difficult, creates a lot of uncertainty, um, a complicated process, and not predictable at all for project sponsors who want to go in and be able to build the things that we need for our economy to move the goods, people, and information in a timely and quick manner.
Thank you, Chad. So, Chris, how did this case make it to the U.S. Supreme Court? It's kind of an unusually styled case, not one that if you look at it, you would think were a NEPA case because there's no federal entity in it. There's a county that's the respondent here. So it definitely, but it would help to sort of lay out how this came about.
Yeah, the players here are petitioners Seven County Infrastructure Coalition, which is a subdivision of the state of Utah whose members are 7 counties, plus entity called Uinta Basin Railway. And they propose to build an 88-mile or so rail line in the middle of nowhere in Utah to connect to the national rail system in order to make it easier to export natural resources from this remote basin, right now only accessible by 2-lane highways, basically, so they could get products to market, including some petroleum products. The construction of a rail line requires the approval of the Surface Transportation Board, which is the successor federal independent agency to the old ICC. And its mission is to evaluate sort of the economic competitive consequences of approving a rail line, and assuming that it's not inconsistent with public necessity and convenience, go ahead and approve it. So they're in the environmental regulation business and not the environmental enforcement business. And a bunch of people objected to the proposed rail project, including Sierra Club Center for Biological Diversity, a lot of the traditional opponents of major infrastructure projects. And they claimed that the environmental impact statement that the Surface Transportation Board prepared in advance of its approval of the project was deficient for a variety of reasons, including that it failed to adequately evaluate the potential impact in the Gulf Coast states of petroleum products shipped by rail from Utah to refineries along the Gulf Coast. And so there was a dispute at the Surface Transportation Board about whether the board had to evaluate environmental impacts that were not within its jurisdiction. In other words, had the Surface Transportation Board decided to evaluate air emissions from refineries in Louisiana, it had no authority to require them to be limited or restricted in any way. So STB's decisions are appealed directly to the Circuit Courts of Appeals. This went to the DC Circuit, and which reversed and agreed with the Center and the Sierra Club that the board's environmental impact statement should have evaluated some of these distant rail line impacts, such as emissions from refineries along the Gulf Coast, 1,000 miles away. The petitioners sought sort of petition discretionary review at the Supreme Court, arguing that the DC Circuit's opinion was inconsistent with historic Supreme Court precedent interpreting NEPA, which basically holds that agencies are not compelled to evaluate environmental consequences that are outside its jurisdiction.
So one of the key issues in this case is what's the standard of proximate cause when looking at these effects, and do they raise to the level of something that the agency should be looking at? What's the standard? What's the test that petitioner is asking for here, and how does it differ from what the DC Circuit decided?
Well, the DC Circuit petitioner is basically saying you should borrow the doctrine of proximate causation from the tort world, or adopt a rule of reason, as Supreme Court has done before, and sort of limit the range of impacts that need to be considered to those that sort of make common sense. Here, for instance, the petitioners concede that the impact of running rail across 88 miles of land and potential species habitat need to be considered on the EIS, of course. Where they depart is whether things remote jurisdictionally and geographically need to be included in that analysis. And what the DC Circuit did, contrary to Supreme Court precedent, was basically adopt but-for causation. And they basically said, well, perhaps it's true that the Surface Transportation Board doesn't have any ability to regulate refineries in Louisiana. But on the other hand, if they would have declined to approve this project, then none of those impacts would have resulted. So under that scenario, of course, everything is subject to but-for causation. And if the rule under NEPA is agencies with no authority to do anything other than say no need to evaluate impacts that would be avoided if they simply say no every time, then there's really no reasoned principle that would apply to impacts that need to be evaluated.
So how broadly does STB's regulatory authority sort of sweep? Is they do have a sort of broader public interest authority. Has that played at all into the decision as to what the authority is of the agency and whether the effects fall under their responsibility?
Yeah, the project opponents certainly argued that. The STB's mandate is to evaluate sort of public convenience and necessity, but from an economic regulatory perspective, similar to state utility commissions. And so, they look at whether something would create monopoly power or harm consumers somehow from a reasonably regulated marketplace sense, as opposed to, they're really not in the environmental business, other than like all federal agencies, they have to comply with NEPA.
Let's talk a little bit about the impacts that the DC Circuit and respondents believe that STB should have considered. Chad, what can you talk a little bit about what those impacts were, and how remote that they would be, both in terms of STB's authority and geographically remote as well?
Yeah, I think probably the biggest one is if you're talking about the combustion of the oil that would be transported over the train, would be the impacts on climate change. And so certainly global impacts are about as broad as you can get in this definition. But there were a whole suite of different actions that they wanted them to look at, under the Endangered Species Act, impacts on sagebrush, grouse. So, do we have to look upstream at the production of, the oil and gas, and to see if that impacts critical habitat? And then, if you're looking at the Uinta Basin, there were cultural and, tribe considerations under the Historic Preservation Act. So there are a whole suite of things that, the Surface Transportation Boards, if you look at their mandate, becomes really challenging for them to really look at, and the effects of these things can be quite difficult. The kind of things that we often see in these cases, for water quality, if you're looking at like fish, impacts on streams, oftentimes those impacts are not just around or near where the stream is, but the courts and the litigation is pushing for folks to consider things even further downstream on the whole river basin. How far that has to go. I think it's continually expanding and becoming bigger and further away from where the actual project is.
Mario, the discussion of climate impacts obviously has garnered a lot of attention in the media and sort of publicly in general. The law professor's brief talks about whether or not STB has authority to consider such impacts. Do they?
Well, so getting back to where the DC Circuit differs with the petitioners here, what the DC Circuit would say is, we all agree that that an agency only needs to study reasonably foreseeable impacts. The question is, what impacts are reasonably foreseeable? The petitioners here rely on a 20-year-old Supreme Court case, Department of Transportation versus Public Citizen, famous case, where Justice Thomas talked about borrowing the concept of proximate causation from torts. But that case was a little bit sui generis because the agency had no discretion in that case. The agency action that was triggering NEPA was a non-discretionary action that was triggered by a presidential determination, and that is not really that doesn't really fit the pattern of the typical permit decision. And really, the way that the DC Circuit looks at it, at the other end of the spectrum, where you have an agency decision that is predicated on this, early 20th century language of public convenience and necessity, the technocratic stuff, which you could argue is the broadest possible discretion that an agency could have, because of course, what's in the public interest? Well, anything could be in the public interest. Certainly fighting climate change could be in the public interest. And because in the DC Circuit's view, the agency had sweeping authority to determine what was in the public interest, it could, unlike the agency in Public Citizen, the Surface Transportation Board here did have the statutory power and discretion to prevent the downstream impacts. Therefore, it had to study those downstream impacts. And there are, multiple problems with that, but one big one that that I hope the Supreme Court will focus on is the fact that NEPA can't be interpreted in isolation. There's also the Administrative Procedure Act. And what does the Administrative Procedure Act tell us? The Administrative Procedure Act in Section 706 sets up a system of deference schemes that depend on what are the, it's a distribution of deference scheme according to the core competencies of the various branches of the government. And the Loper-Bright decision, the Supreme Court reversed Chevron and arguably restored the fidelity to Section 706 of the Administrative Procedure Act in holding that it's the province of courts to decide what the law means, not agencies, and that we're not going to defer to agency interpretations of statute because agencies have no particular expertise in interpreting statutes. Courts do. That's what Roberts said. The other side of that coin is that the determination of what is a significant impact, whether upstream increased oil production or increased fire hazard along a rail line or increased fire hazard along the rail lines that this rail line is connecting to, or increased refining activity at the downstream refineries, or increased global emissions. Which of those things are significant and not significant? That does lie within the core competency of the agency, where courts are supposed to be the most deferential and are supposed to only set aside agency findings if they are arbitrary and capricious. And here what we have is this real 1-2 punch where the agency is saying, in the things that are clearly within Surface Transportation Board jurisdiction and expertise, such as what is the fire hazard along the 87-mile rail line that we're looking at here, biological, consultation under Section 7 of the Endangered Species Act, what's the impact on endangered species? The DC Circuit didn't defer to any of that. It just said, no, you're wrong. We don't really agree with this, and we don't really understand, and you're just wrong. And then on the other hand, it found fault with the Surface Transportation Board's quite proper refusal to engage on an extensive study of climate impacts, saying that these are all reasonably foreseeable and therefore they should. And so it begs the question, given that nobody at Surface Transportation Board knows anything about climate change, or it's their job, it doesn't get paid to know anything about climate change, and that Section 706 of the Administrative Procedure Act suggests that if they had gone on an extensive assessment of climate impacts and had based a permit decision on that extensive examination of climate impacts, not only would that not be due deference, but could arguably be arbitrary and capricious for taking into account factors that Congress did not intend the agency to consider, right? This is all language from State Farm. And so it begs the question of, if the DC Circuit was not willing to show any deference to the court, to the agency, on the matters that are at the very core of the agency's jurisdiction and expertise, why is it demanding that the agency, why is it saying that the agency should have engaged in this extensive examination of impacts that are far beyond its jurisdiction and expertise, and as to which anything almost by definition would be arbitrary and capricious? And as a matter of fact, in West Virginia versus EPA, the Supreme Court said, and I quote, "When the agency has no comparative expertise in making certain policy judgments, we have said Congress presumably would not task it with doing so." And I think that the key point is that Section 706, if everybody, Section 706 of the Administrative Procedure Act has to be applied consistently with NEPA and supplies a clear limiting principle on the downstream and upstream impacts that an agency has to study under NEPA.
Mario's brief goes into this in quite good fashion, but the problem with the DC Circuit opinion, among other things, was that the STB is basically entrusted by Congress to evaluate the adequacy of passenger and freight rail service. That's their expertise. And as Mario pointed out, it's rather ironic that the DC Circuit found that the Surface Transportation Board was not competent to understand what was within its congressional mandate and what was without. And then once having said that, said that the Surface Transportation Board was perfectly capable to evaluate far-flung environmental impacts 1,000 miles away.
Thanks, Chris. So one of the other arguments that the law professor's brief makes is that the Center for Environmental Quality lacks rulemaking authority. The separate case just 3 weeks ago, the DC Circuit, sort of almost completely on its own, held that the CEQ rules were ultra vires. Mario, could the issue of CEQ rulemaking authority be decided in 7 counties? Could you sort of lay out what the argument that your brief made?
Yeah, and I think it certainly is more central to the decision in 7 counties than it appears to have been for the decision in Marin Audubon Society, the DC Circuit case that you mentioned. And you know, the one good thing about Judge Randolph's opinion in the DC Circuit case, or one good thing about it, is that it's sort of, the way that I look at it is that Judge Randolph basically in that case, the DC Circuit panel in that case, shot a flare over the oral argument that's going to happen next week. Saying, hey, now you have to examine this issue, which you've kind of been skirting around for many decades. And part of the reason is that so to answer your question squarely, a lot of this litigation rests on discussions of cumulative impacts and indirect effects being defined in the CEQ regulation to include growth-inducing effects, and this kind of language that the CEQ regulation just basically expands the scope of analysis basically at every step in the NEPA process through this combination of procedural and definitional add-ons. But it seems to have escaped everybody's notice for 40 years that there is no delegation of rulemaking authority in NEPA. There is nothing in NEPA that says CEQ shall promulgate rules to accomplish X, Y, or Z. And we know from Supreme Court cases going back to Youngstown Steel and from the separation of powers itself that the president cannot by decree create law or create judicially enforceable law. But this is a regulation that was cleverly dressed up to look. This was cleverly dressed up to look like a regulation. It was passed through notice and comment rulemaking. Everybody has treated it as a regulation. It has certainly expanded the litigation target area of every NEPA review. And many permits have been vacated on the basis of agencies not meeting requirements that are not spelled out in the statute, but were invented out of thin air by CEQ in this so-called regulation. And I would just, so in Public Citizen again, 20 years ago, Justice Thomas said, in passing, very, very much in dictum, as Judge Randolph points out a few weeks ago, Justice Thomas said something to the effect of CEQ was created by NEPA with authority to issue regulations interpreting the statute. I think Justice Thomas is quite possibly the least vain person on the Supreme Court, if I may say, and would probably not find himself very beholden to that dictum. And actually, I imagine that he would be considerably annoyed that he had been misled by everyone behaving as if this was a regulation when it really wasn't a regulation, and would probably rebuke, it's easy to imagine him rebuking all the lawyers that pretended that there was a delegation of rulemaking authority here when there wasn't. And why does that matter? Well, because to the extent that we can put this entire cottage industry of litigation that has cropped up around NEPA, which is a law that not only does not delegate rulemaking authority to CEQ, but doesn't even contain a private right of action. This is something that was part of the democratic process. These were good governance procedures that Congress was prescribing for federal agencies without any apparent intention of ever creating a private right of action that citizens could go and sue for enforcement of. And this distinction is an important distinction. Does CEQ have a role in guiding agencies in their implementation of NEPA? Absolutely. The CEQ regulations are an important managerial tool, the CEQ regulations. But the way that Executive Order 12866 or any number of other presidential directives are that guide and harmonize administrative procedure among agencies, But there is no, if the president, like I tell my students in administrative law class, if the president says everyone has to go home by 5 p.m., anybody who's still in their office at 5:30 p.m. is fired. And some, good citizen is walking outside the Department of Interior and notices that there's a light on up there at 6 p.m. and somebody's still in their office. Does that person have standing to sue to enforce the go home at 5 p.m. directive from the president? Of course not, because it's not a law. It's just a managerial directive. And so, I think the correct position is to be that CEQ should be as descriptive as a president wants it to be. By the way, should President Biden be free to require agencies to do climate impacts as part of their permit determination? Should he be free to require agencies to do environmental justice impacts? Absolutely. That is, elections have consequences, and that's fully within the president's prerogative under Article 2. The question is whether the failure of an agency to implement the president's policy can be enforceable can be remediated by courts. And I think in a Supreme Court that is increasingly solicitous, one of the central threads of this court's jurisprudence, of the Roberts Court's jurisprudence, certainly in the Gorsuch and Amy Coney Barrett eras, is solicitousness of the Constitution's separation of powers and real care about where the separation of powers fits in with the administrative state. And I think that here we're likely to see the Supreme Court being much more careful and taking a scalpel to these things. This is the common denominator, right? In West Virginia versus EPA, Loper Bright, and now 7 counties, where I think the Supreme Court has a chance to really reimpose some important guardrails on the traditionally very expansive discretion, even arbitrary discretion of the administrative branch.
Chris, do you have any thoughts on the CEQ rulemaking issue?
Yes, I think it's true that CEQ's rulemaking authority, such as it is, originally derived from the executive order during the Carter administration. They have no statutory mandate. And so I think Mario's brief is correct that CEQ doesn't have any rulemaking authority that can bind federal courts in NEPA litigation, which is brought under the Administrative Procedures Act. It should be treated as nothing more than guidance. Whether in this particular case the Supreme Court wants to leap into that issue is still uncertain. But nothing would surprise me. This court obviously is no longer an incrementalist court, and they may think that this would be a good time to take up the issue of whether courts facing NEPA litigation should necessarily use the CEQ regulations as sort of a checklist to double check agency work, or whether they should go back to where they started, which was interpreting the meaning of the words in the statute and deciding whether what an agency produced was not arbitrary, not capricious in support of its decision.
Thanks. So Chad, your work and the work of the Institute at the Chamber has involved you in broader efforts to reduce barriers to energy development and investment. Where does the question before the court in this particular case fit into that sort of broader landscape?
Yeah, that's a great question. I think if you look back at over time where we've been on energy, the U.S. has abundant domestic energy. And with the recent conflicts in Europe, I think energy security is back front and center, and making sure that we have adequate resources here that we can develop and continue to make them cleaner, and also support our allies in Europe. If you look at the demand out there for energy, it's just going up across the board. If you look, industrial demand 5 to 32%, EIA is projecting. Oil and gas up. Everything, electricity, if you look over the last decade, it's been pretty flat, 2 to 3% demand increase, but we've seen it, they're projecting as much as an 18% increase by 2030. So, massive shift in energy, but shift, but also increase just across the board. And if you want to be able to supply all that energy, you need to be able to build stuff, and you need to be able to build it quickly. Whether it be electric transmission lines to connect, renewable energy or natural gas pipelines, or LNG exports, whatever it may be. If you look at electricity more closely, in particular, there's a move. The federal government has been pushing appliances to be electrified, pushing them away, your furnaces and stoves and things to electrify them. Electric vehicles, of course. Global demand is supposed to be 6 to 10 times increase in electricity by 2030, abroad, and big increases here in the US as well. So a lot of things are being put onto the grid. And then you compound that with the massive explosion in AI and the demand here that's created for more electricity, not just any type of electricity, but really highly reliable, consistent electricity. It's why you see some of the tech companies making agreements to plans to start up 3 Mile Island, right? Who would have thought that would have happened? Or making other agreements with utility companies that run nuclear power and setting up their data centers around those sources of power to ensure that they have consistent, reliable electricity. It's something we take for granted, that we turn the lights on, it's going to be there. But with all this demand from all the electrification, energy we need here to support our own growth, to support our allies, we're going to need to build a lot of stuff. Certainly, the Inflation Reduction Act has driven a lot of the renewable energy growth that we've seen, almost 400 billion in incentives across the board that are driving a lot of that. So there's a lot of funding out there. There are 26 permits for LNG exports that are on hold, that have been blocked. And if those open up, there's going to be a need upstream to supply that natural gas. What's kind of exciting in that end is currently the U.S. exports 3.5 exajoules of natural gas. But if you look at the amount of coal that's consumed around the world, there's 161 exajoules of coal consumption across the world. And a lot of this natural gas would go out and support the displacement of some of that coal, driving cleaner energy. So there's just a lot that's needed across the board, whether it be renewable or natural gas, or nuclear, coal. We're seeing coal-fired power plants as well staying on longer than what utilities initially had planned, because there's so much energy demand. So again, we just need to build stuff. We need to be able to build it quickly. And, to get a mine permitted to provide the critical minerals that are used in electric vehicles, the cycle, it's taking decades to get these things done. To get electric transmission lines, same thing. And then natural gas pipelines in some states, they're, in regions are being blocked completely through the permitting process. But there's real need for project sponsors to have this ability to be able to go through a process, know that they want to get into the permitting process. This is how long it's going to take. These are the requirements they have to meet. And economically, the country is just going to need to build a lot of stuff. And what's great is we have the best environmental standards in the world, for air and water and land management. So let's build it here in the US. So there's a big call out there for the business community, for the energy sector in particular, to meet these challenges, to be able to support AI and the electrification of certain sectors of the economy, and just moving things. And there's a lot happening. So it's an exciting time to be in energy. We're excited about all the things that can and hopefully will get built into the future.
Certainly, if anybody in this area, in the DC area, needs an illustration of that, go drive around Loudoun County, in Ashburn and Dulles area, where you have data centers popping up left and right, and you sort of wonder where's all the energy coming from to keep these things running.
And I have a good anecdote for that. Dominion Energy is projecting by 2030, one out of every third electron they produce will go to AI.
Wow.
And we have 455 data centers in Northern Virginia, more than anywhere else in the US cumulatively, and more than any other country in the world. And it's important from not just being able to do smarter searches, but from a national security standpoint and business standpoint. In AI, ChatGPT takes 10 times the energy as a Google search. So that's where the energy's going.
Chris, the brief that you and your colleagues from Perkins Coie did a really good job, I think, of illustrating some of the examples of how the NEPA process has delayed or deterred mining and exploration projects. Can you summarize some of those for us?
Sure. And picking up on what Chad said about delay and impediments, in the West, close to 50% of the land in the 11 Western states is owned by the federal government, and another big hunk is also owned by Native American tribes. So anytime you want to do anything on federal or tribal land, you have a NEPA trigger. Any major infrastructure project, including mines, typically would require an environmental impact statement. And as we noted in our brief, and some of the average timelines that you mentioned at the outset about how long things take, CEQ keeps track of that, among others. But a lot of the average time to complete an EIS is watered down by the easy no-brainer projects, and the things that really take a long time include mines. And it actually, recent study said it takes 29 years in the United States to get a brand new mine permitted, and that's second longest in the world after Zambia. So it's good that we're ahead of Zambia, I guess, in our efficiency with respect to environmental review. But it's not all that comforting. There are one of the projects we noted, there's an Asarco mine in Arizona that's existed for close to 100 years. They wanted to enter into a land exchange to sort of consolidate their holdings. And this was an area of long-time historic mining, but the environmental analysis to support the sort of perfunctory land exchange in an already impacted area was 20 years. Another project, Resolution Copper, a joint venture between BHP and Rio Tinto, is looking to expand an existing mine in historic mining area in Arizona. The federal Congress passed a law in December 2014 saying this is an important project for America, for our economic security. So we're ordering the Forest Service to, quote, facilitate and expedite a land exchange to sort of consolidate mine holdings again and make them a little bit more accessible. That was 10 years ago, more or less today. And the final environmental impact statement was released and then withdrawn and currently is in limbo. So, the way NEPA works in practice is, and that's just on the agency side of things. And so, things get held up additionally in litigation subject to what the court may decide here in Seven County. Getting back to the electrification issue, that one irony is that environmental groups, of course, are the ones who most often invoke NEPA in litigation for environmental good purposes, they claim. There's a little bit of a split on the environmental community now between those who sort of invoke NEPA for protection of bugs and bunnies or scenery, and those who are concerned that things are grinding to a halt to the extent that we will be unable to combat the effects of climate change. There's a Columbia professor, Michael Gerard, who's sort of a climate change warrior, wrote almost 3 years ago now that proceeding under the business as usual approach of NEPA, where everything is delayed for years or a decade, would lead to a, quote, world of killing heat and mass human migration and species extinction. So, that sounds less important to me than snail darters or whatever the cause of your NEPA delay may be in any given project. I could rant for 2 hours and I'll try to restrain myself, Glenn. So why don't you start?
Can I jump on that rant a little bit?
Absolutely. Go right ahead.
Because this is something that I've tried to highlight for folks as well, is that you've got, what the Biden administration showed consistently in its 4 years is that while touting climate change and decarbonization as an upper level, as a 30,000-foot goal, in reality, on the ground, it was systematically selling out to the first group of environmentalists that Chris mentioned, which are the ones that are invested in stopping any project, the people who rise to the fore that organize to stop any particular project, the bananas crowd, we call them, that build absolutely nothing near anyone anywhere. And we see this, for example, in the in BLM's solar plan for the southwestern, for 11 states in the West, which essentially took 80 or 90% off of the land that could have been viable for solar projects off the table right off the bat, and then required all these crazy things like no grading, all these requirements that are impossible to meet. And you have this situation where they just seem not terribly concerned with the fact that while we are retiring nuclear and retiring coal and retiring natural and constraining the ability of natural gas capacity to grow in the United States, the solar and wind and other stuff that's supposed to be gangbusters is not actually coming on the grid, or much less batteries, at anywhere near the scale or speed that would be needed to make up for the loss of the baseload generating capacity from coal, gas, and nuclear, if it were even possible for variable sources ever to make up for that lost capacity. And so I would say, to add to Chad's very genteel way of describing this, we're headed towards an energy scarcity crisis in the United States right now, with a severely constrained grid and soaring projections for demand. And we're going to need a very rapid build out of all kinds of power plants. And they are not going to be able to get through a process that has been built up. That's a joint project of activist courts from the 70s, 80s, and 90s, and environmental advocacy groups that have created red tape that snarls all sorts of projects, whether they're renewable energy projects or anything else, in years and years of red tape and litigation. And again, this is all a cottage industry that has mushroomed, that is tying up ENRD at Department of Justice in hundreds of cases at any given time, that has mushroomed around a statute that itself created no private right of action, and over a regulation for which CEQ had no statutory rulemaking authority.
If I can jump in again, just the brief for Seven County, the petitioners, was prepared by Paul Clement, who's a very famous Supreme Court litigator, and the NEPA folks at Venable, Jay Johnson and Fred Wagner, who are quite good. And this is worth a read. You can go to the Supreme Court website and download their brief. But among other things they said is the decision below converts NEPA from a sensible procedural check on agency actions into an anti-development treadmill. Not even Helen Palsgraf could have dreamed of a judicial opinion finding 88 miles of track wholly in rural Utah to be the proximate causation of future air pollution on the Gulf Coast. So it's a pretty striking case, what the Supreme Court wants to do about it. A lot of folks who filed an amicus brief hope that the court takes the opportunity to sort of rein in especially the lower courts, you know, if you're a federal agency and you know you're going to get sued, whatever you do, you're going to be pretty risk averse, and that produces increasingly more lengthy and laborious environmental impact statements. So I think the first order of business for the Supreme Court is to tell the lower courts to cut it out, especially the Ninth and Tenth Circuits here in the West, and get back to sort of the rule of reason articulated by the court itself in the earliest cases. And hopefully with that, the agencies will no longer be paralyzed by fear.
So what sort of things do you think people should listen for when they're listening to the oral argument, Chris? Are there particular justices that you expect will be more engaged than others, or signals that people might hear in the process of the argument as to where their thinking might be?
Well, I think it's probably a given that the DC Circuit will be reversed. And so the question of the hour will be how much more than simply reversing the DC Circuit as inconsistent with prior NEPA rulings by the Supreme Court will the court go? And I would suspect there's a lot of sentiment for going pretty far to fix NEPA more than just reversing the Ninth Circuit. And I would think, you know, Justice Thomas and Alito probably will be fairly vocal about the need to do something dramatic. Justice Gorsuch, obviously a former 10th Circuit judge, he knows about the problems of federal land holdings in the West and the frequency of NEPA triggers. And so, you know, Justice Ketanji Brown Jackson is typically the most vocal justice on cases of all stripes. I don't know necessarily that she will be here, but I would listen for questions of the government about the government's brief sort of attempted to save the potential future option of evaluating climate change as a cumulative or direct or indirect impact for another day. And so they urged the court to basically issue a narrow ruling saying the DC Circuit got it wrong, but don't rule out the need to consider remote climate change impacts in every case. And I think what the justices have to ask about that and how the government responds will be a big clue on how narrow or broad the court's ruling will be.
Mario, any thoughts to that question?
I would. Yeah, that's great. That's great insights, Chris. And I would add to that you know we have several justices on the court. I think of course Clarence Thomas, and that were justices themselves on the DC Circuit and that are real experts of Brett Kavanaugh, of course, real experts in administrative law. Justice Thomas's opinion in Public Citizen was not the first NEPA opinion that he's written. He also wrote some very important NEPA opinions when he was at the DC Circuit, and Justice Kavanaugh as well. And Justice Gorsuch. I mean, Justice Gorsuch is going to be looking, if you look at his concurrence in West Virginia versus EPA, and again in Loper Bright, he's going to be sounding the importance of remembering separation of powers and of being cognizant of the separation of powers and of the fact that the president cannot, under the president's sole discretion, create law. You know, there is another case that could be mentioned here, which is Vermont Yankee, and this is something that Brett Kavanaugh for many years at the DC Circuit kept saying, you know, I don't know if Portland cement is still good law given Vermont Yankee. What does that mean? That means that courts are not supposed to be adding procedural requirements to agencies that are already subject to statutes that create procedural requirements, right? And so if you think about it, what the DC Circuit did below is very similar to what the DC Circuit did in Portland cement back in the 1970s, which was to create this out of the clear blue sky, pull a procedural requirement that's not in the statute. and which Justice Kavanaugh has indicated at multiple reprises is incompatible with Vermont Yankees' dictum that courts should not add procedural requirements to agencies that are already subject to a procedural statute. And so I think that there's going to be not just a reversal of the DC Circuit's opinion here, but likely a strong majority, at least 6 justices, to reverse. And the question is, how broad will the scope of that reversal be? I totally agree with Chris. This is not an incrementalist court anymore. They're seizing on the opportunity to right the ship where they see that decades of errors have gone unaddressed and have created more problems than a constitutional avoidance would solve. And so I think it's very likely that we're going to be in for some real fireworks in the oral argument. I'll be right there, maybe not in the front row, but I'll be right there in the oral argument, hopefully, and hopefully see some of you there as well.
Thanks, Mario. So Chad, I'll give you the last word here. What sort of outcome would be an ideal outcome for a business group like the Chamber, not just a reversal, but how the opinion itself is written?
Well, for us, I'll start at even higher level. We really need a predictable, efficient, and transparent permitting process. And, we talked about all the things we need to have built in this country. And, in the end, whatever the Supreme Court decides, we just hope that it helps drive that in the federal agencies and their NEPA processes and procedures, that when a project sponsor comes in with a $100 million, $500 million project, that they know that it's going to take 2 years to get through. They know generally here are the things that they have to meet. And it's not riding roughshod over environmental issues. It's, it's trying to get these decisions done in a faster way. And of course, in order to do that, it's going to require narrowing some of what the agencies, have been claiming as their power, at least where litigation has pushed them. So, we did in our brief talk about what Mario was just saying, the major questions doctrine, and our agencies fabricating authority here that really isn't written into this into the statute. So I think ultimately we're looking for something that is a better process and that allows us to build the things that the economy and consumers are asking for. Whether it's broadband, better broadband for our small businesses, or better roads and bridges so we can all go to school and work and do those sort of things.
Thanks very much, Chad. Thanks everyone for joining us today as well. And thank you to our speakers. We'll be doing another webinar on December 12th, which has some relation to this. It's going to be focusing on citizen suits under the environmental statutes, which I think has taken on a even more significant role for the opposition to the incoming Trump administration. We'll have 2 attorneys from Aaron Fox Schiff talking about that and how some of the administrative law decisions from the court last couple of years have had an impact potentially on the bringing of citizen suits. Again, thank you very much for joining us today. If you came in late or you know of anyone who might be interested in watching this, it'll be available on our website as an on-demand video. Finally, when you sign off, there'll be a very short survey that we would ask you to do. And wishing everyone a happy holidays.
Thank you.